Hello and welcome to Creating Family Legal Documents, hosted by Motherhood Uncovered. Thank you for taking the time to join us today. We are so excited to have you here with us to hear more information about a sometimes difficult to think about topic, but very necessary one. Soon, our expert, Ms. Geller, is going to be giving you a lot of really great information, but first, I want to tell you a little bit about the logistics of today's webinar and a little bit about who we are. So first, you can ask questions by leaving comments on the YouTube page below, and we will attempt to address them after the presentation. If we run out of time, we will keep posting answers. So check back. We will answer your questions the best we can, so ask away. Also, feel free to email questions to Sarah or myself. Our emails are listed here. And also make sure you are connected to Sarah Wells Bags or at NizzoWare on social media, because in 2 short weeks we are going to be doing some giveaways at our next event and you are not going to want to miss out. I'll talk a little bit more at the end of our presentation about this. And lastly, this video webinar will be forever archived on the same link that you are watching right now. So you can rewatch, you can pause, you can share with your friends, or you can embed it into a blog or a website or an email. So who and what is Motherhood Uncovered? Well, my name is Nicole Zollner, and I'm the CEO and founder of NizzoWare Nursing Bras and the co-founder of Motherhood Uncovered. I've joined forces with the amazing Sarah Wells from Sarah Wells Breast Pump Bag to form the Motherhood Uncovered collaboration. Our mutual goal is to connect new and expectant moms with experts who can share straightforward and helpful information regarding all topics motherhood. We aim to cover a wide range of topics in this series that moms want to talk about, but may not always hear about, or sometimes may not even know to ask about. Since both Sarah and I are mothers, we do have a great basis for these topics, but we're ultimately doing this for all of you. So please post your comments and questions below or email us on what you want to hear more about, as we love hearing from you guys. And while we do have a personal experience with this whole motherhood thing, we are not experts on every topic. This is why we've hand-selected the very best in their fields to interview for you so that you get the most accurate and up-to-date information. We really hope that you guys enjoy today's topic, and if you've missed any of our previous topics, you can check them out on our website, motherhooduncovered.com. Let me tell you a little bit about myself real quick here. As I stated before, I am the founder and CEO of NizzoWare Nursing Bras, the only patented nursing bra with a pocket in the pull-down flap. Our pocket holds removable pads that provide moms a little lining when they want it to cover up nipples or nursing pads or light leaks, and it also provides great shape. But then you have the ability to take them out when you don't want it. The pocket can also hold a warm or cool pack that provides relief to any breastfeeding discomfort that you might encounter. And the idea came from my personal experience breastfeeding my son. For me, it was a bit painful, so I set out to provide mothers with a nursing bra that could do it all for them. To not only make a comfortable nursing bra, but make one that gave mom options and looked good too. To hear more about our story or to check out our products, you can go to our website at nizzoware.com. Now I'd like to introduce you all to my Motherhood Uncovered co-founder, Sarah Wells.
Hi everybody. Good afternoon or morning, depending on what part of the country you are watching from. Again, I'm Sarah Wells, CEO and founder of Sarah Wells Breast Pump Bags. So happy to be here partnered with Nicole on what is a really important topic today. A little bit about myself. I created my small business out of my own personal frustration carrying a pretty ugly black bag that was created by a pump manufacturer back to my job in Washington, D.C. after the birth of my daughter. And so coming up with some better ideas, I decided to launch it into a full-fledged business. I've been around for just about a year now with one design, the Maddie bag, which you can see online at Amazon or sarahwellsbags.com. And I have 2 new designs coming out this fall, so I hope you will check it out. So with that, I'd like to introduce the presentation that we have today, which is Creating Family Legal Documents, Tough to Think About and Critical to Have. I think the title really does sum it up, that these are complex topics that no expecting or new parent really wants to think about, but having a baby, or a second, or a third, or so on, really does come with some important legal tasks that you need to cover in order to keep you and your loved ones protected. So we are so lucky to be joined by a top expert today, whom I was lucky enough to meet in college, and from there develop a friendship and professional support network as well, Rebecca Geller. Rebecca Geller is president and CEO of the Geller Law Group. She's a seasoned lawyer committed to providing affordable, high-quality legal services to businesses and families. Before launching her own law firm in 2011, Rebecca worked as a corporate lawyer at a major international law firm representing Fortune 500 companies. Her experience is varied, including work in wills and trusts, corporate, trademark, family law, litigation, housing, political law, telecommunications, employment, and nonprofits. And while serving as the chair of the Fairfax Bar Association's Business Law section, Rebecca received the 2013 President's Award. She serves on a number of boards and nonprofit organizations and regularly volunteers with the community. Every month, Rebecca teaches a seminar for the Small Business Development Center about the legal aspects of starting and running a successful business, as well as counseling new entrepreneurs. Phew, not only is Rebecca an amazing leader in her professional field, but she also happens to be the super mama of 3 amazing children, so she understands the issues we're going to talk about today really from all of the angles. And with that, I'd like to turn it over to Rebecca.
Thanks, Sarah and Nicole. It's great to meet everyone. I'm really excited to be here and be meeting everybody virtually. As Sarah said, I own the Geller Law Group. We're based in Northern Virginia, right outside Washington, D.C., and my firm has 5 attorneys and a paralegal, and we do work in Maryland, D.C., Virginia, and North Carolina. And my firm focuses really on 2 areas of law. As Sarah mentioned, I came from a firm with about 500 attorneys and did work for companies like T-Mobile, HBO, CVS Pharmacy, and now I focus on families, individuals, and small businesses. I'd say most of our practice works with small businesses to do trademarks and contracts and general legal work, and the other half is working with families, especially moms. We have a joke that we are lawyers to the moms. You know, some people are lawyers to the stars. We're lawyers to the moms. We're bloggers, and we find most of our clients who are families are coming to us because they have children and they want to set up documents to make sure that if something happened to the parents, that the children will be taken care of physically as well as financially if something were to happen to the parents. It's a topic that I know people don't like to think about. I'm a mom myself. My kids are 5, 3, and I have a 5-month-old, and it's something none of us ever like to imagine what would happen if we weren't there. But being in the work that I do, I've seen it happen time and time again where families are distraught because something has happened, an emergency has occurred, and they did not have documents in place. And so coming from that end of it, it's something that is really buying yourself peace of mind to take the time and work with an estate planning attorney to figure out the documents that you need. So with that, we'll launch into the meat of what we're going to talk about today. And the legal term for it is estate planning. But to be honest, I actually avoid using that term because a lot of people shy away from it. They think that estate planning is really for people who are the uber wealthy. And the reality is everybody has an estate. So the first question is, what is your estate? It's basically whatever your children would inherit if something happened to both parents. So for a lot of people, they always say to us, well, I don't really have a lot. I don't need to create fancy documents. But the reality is people usually have many more assets than they realize. Do you have life insurance? A lot of people have life insurance through their employers. If you have life insurance privately or through your employer, that's usually a pretty significant asset. A lot of people usually have a couple $100,000 of assets, of life insurance. Do you own your home? Do you have a rental property? If you have real estate, then if you have any equity in the home, you have assets. Do you have a retirement account, a 401k, an IRA? Are there other stocks, bonds? Anything that you have, that's considered your estate. So the first step is that we figure out what's in your estate. And everybody's family is a little bit different. There's really no one-size-fits-all. What's right for a family that one parent may have been married previously or had kids from previous relationship, or one spouse is not an American citizen versus a single person or a single person no kids is going to be very different than a married couple with children, as well as for same-sex couples too. So it really does vary. But the first question is looking at the estate. Now this is something that you also have to look at your own state. Each state has its own set of laws that govern this. For the most part, a lot of the issues are similar, but the nuances are different. For example, is there an estate tax? Estate tax basically says your estate will be taxed if it's over a certain threshold, and that threshold changes. And this is actually an area of law we're seeing that's changing quite quickly right now. I know where we practice, Maryland has just changed their laws just this past summer. So it's something that people really need to make sure they're working with a seasoned estate planning attorney to make sure they're doing it correctly. So we'll go on to the next slide and go into the next step. So the first question, now we figured out what your estate is. So let's say your estate is $2 million. Let's say each spouse has $800,000 of life insurance plus, $200,000 in real estate equity and retirement accounts that have about $2 million. And I'm just using this as an example. The next question is, well, what is it we're creating? Are we doing just a simple will, or are we also doing a revocable trust? For many people, if you have any sort of assets, life insurance, retirement accounts, real estate, and if you have children, a revocable trust is really what you need to look at. So if you're working with an attorney, definitely ask them about a trust, especially if you have young children. The reason for this is that you imagine if you just have a will, if you don't have a trust, or if you just have nothing at all, but let's say you just have a will. If you just have a will, that sets up so that if something happens to both parents, the assets will go to the children directly. What this means is that when the child turns age 18, that child would inherit $2 million straight up cash, no strings attached. So if that child wants to take the $2 million and buy a Lamborghini or go on a trip around the world and not save any of it for college or grad school or down payment on a house, then they could. And there's nothing anybody could do to say, no, you need to save this money for these kinds of responsible things that we parents like to think our children will use the money for. So having a trust is a way that it gives you those strings. It sets it up so that you appoint a trustee who is someone you trust. They will be responsible for distributing the money to your children until they reach a certain age. The most common age I see is usually anywhere between ages 25 and 30, the idea being that until they reach that point, the big ticket items will have been paid for, college, grad school, etc. And then when they reach that age, say 25, 27, they're hopefully more responsible than an 18-year-old would have been. Many times we see when 18-year-olds inherit money, that money is usually gone within about 12 months. And there's nothing left for other things later in life. So a trust is very, very common for people who have young children. Basically, if your children are under, I'd say really if they're under 25, a trust is something that you need to consider. If your children are older, then you can look at other options, especially for tax issues. But it's definitely something that we really look at. So the revocable trust is the first step is figuring out what it is you need. If you don't have children or if you don't have any assets, you don't own your house, you don't have life insurance, you don't have retirement accounts, then a will may be more appropriate. But for the most part, if somebody has young children, a trust is really the way we're going to look at it. So we'll go on to the next slide. So what the questions people say, well, why trusts? What are the benefits of a trust? We already talked about the fact that it gives you those strings attached, but there's also some other benefits there too. So the benefits here are that it allows you to also have the flexibility of using the money for certain purposes. Within the trust, you can earmark what it is you want the money to be used for. What is the desired result? What is your goal? Do you want your child to be able to pay for college without any debt? Do you want them to be able to have money for a wedding? What are your goals that you want to have? And you can also specify things when they're younger too. Basic things like tuition, health care, housing, and so forth. So it gives you a lot of flexibility. We'll go on to the next page. So another big benefit of a trust is also that it allows you to avoid probate. Probate is the legal system that we have to go through if you don't have any assets. If you don't have any, probate's a process we have to go through if you don't have a will or if you just have a will without a trust. And it's going to vary based on the state, but it's basically the legal system that we go through in order to verify a will. Probate is something most people want to avoid. It can take a very, very long time. I have a client in Maryland right now who her mother died 10 years ago, and the money is still caught up in the probate courts because there's been all sorts of issues and she still hasn't seen it. Now that's an unusual case, but for many people it does take usually at least a year or more depending on your state. And so for many people, as you're navigating the death of a loved one, the last thing you want to have somebody have to deal with is the paperwork and the legal minutia of handling the probate process. It's very time-consuming. Anybody who's been through probate calls us afterwards and says, I just had to go through probate for my loved one. I never want to put my children through this. It was such a headache. It was so time-consuming and such a pain in the neck. So what can we do to avoid it? A trust. A trust avoids probate. One of the other benefits of a trust is that a trust is completely private. Nobody ever knows what's in it except for you, your trustee who you've appointed, and your children, your beneficiaries. So there's a lot of benefits there. In contrast, a will is completely open to the public. Probate is completely open, and it's actually really susceptible to scams because of the convergence of the internet and the legal system. We're seeing a lot of issues with scams coming out of the probate court. I've had a number of clients where they have lost a loved one, and then all of a sudden they start getting these calls. Hey, I'm sorry to hear about your mom. By the way, did you know that she owed me $30,000? You need to pay up. And the child doesn't want to get in trouble and has no idea if this is accurate or not, so they just start paying money left and right. I've had this happen with clients who are in their 40s have had this gotten this call, much less than an 18, 19-year-old child who has no idea, but legally is considered an adult. So we really want to avoid probate, and trust is really the way we do that. So by putting your assets into the trust, it allows you to avoid probate. So next slide. We look at the components of the trust. What is involved in your trust? What are the steps? How do we set this up? So the first step is that we have to create the trust. And by creating the trust, we have to specify who the trustee would be, how we are providing money to be distributed. Most people leave most of their money to their children, but do you also leave money to other individuals as well? Are you leaving it to a sister, a niece, a nephew, a nonprofit? Some people leave donations to a church, to a university, a nonprofit organization. How are you specifying it? As well as, do you have any pets? Do you have a cat or dog? Now, technically speaking, an animal is property, and you can't actually leave money to an animal, but what you can do is specify that you leave money for this person to take care of that dog or cat. Now, a lot of people say, well, I don't want to, how much is my cat going to eat or whatever. Some people like to say, I don't want this animal to be a burden on the person who's going to inherit the animal. I've also had people leave $50,000 to their cat. I don't know what this cat eats. I buy dog food at Costco, but you can do whatever you want here, but it's something you want to think about. Our furry friends are our family too, and who will take care of the animal if something happens to you? So another question I also mentioned in the trust too to think about, is there anybody who you're leaving money to who has special needs? And by that I mean someone who receives benefits from the government in order to pay for their livelihood. I'll give you an example. My brother-in-law has cerebral palsy and is a quadriplegic and receives benefits to help him survive. We can leave him money, but the way we leave him money is through what's called a special needs trust. If he inherits more than a couple $1,000s, and it's very low, I think it's $2,500. If he inherits more than $2,500, then he loses all of his benefits, and that's certainly not what anybody would want to do to a loved one. So if you have a relative, a child, a cousin, etc., who you want to leave money to who has special needs, you can do it, but it has to be done very carefully through a special needs trust. If you have a child or somebody in your life who has special needs, make sure you talk about this with your relatives as well. I had a client last year in D.C. who his great aunt died, and he had no idea he was inheriting $30,000 from the great aunt, which, although a lovely idea, is going to make him lose all of his benefits. And $30,000 is certainly not enough for a 35-year-old man to live on for the rest of his life. So if you know of people who have special needs or this is an issue for your family, this is definitely something you need to work with a seasoned estate planning attorney on. So I mentioned there's 2 steps to the trust. The first step is creating the trust, and this is where we draft it, and we specify who the trustee will be, and then it has to get executed, but in front of 2 witnesses who cannot be a beneficiary and the notary. The second step is that we have to fund the trust. When I say funding the trust, we're not actually moving any assets. When I say funding the trust, basically what that means is that we are going to change the beneficiaries of your assets. So on your life insurance and your retirement accounts, it usually will say the first beneficiary is my spouse, the second beneficiary is my child. The second beneficiary, that's what we're changing. So we're going to file paperwork that says I am changing the second beneficiary so the beneficiary is no longer my child, but instead is my trust. So if something happens to both parents, the money does not go directly to an 18-year-old child, but instead it's held in this trust to be distributed in accordance with the terms that you have specified in your trust of what the child can use the money for. Next slide. Now we're going to talk about the pour-over will. people say, well, do I still do a will? How do I specify what the will has? So when we do a trust, we also do a will together. They work together. There's actually a lot of different kinds of wills. Many people don't realize that. They think there's one kind of will. When we do a will in conjunction with a trust, it's called a pour-over will. You think about a cup pouring into a bowl, the pour-over will pours over into that trust. So in the will, that's where we specify who the executor would be. That's the person who handles very administrative requirements. And obviously the most important decision is who the guardian would be. A lot of people have trouble making that decision, but it's obviously the most important decision to make is who the guardian would be. One thing to think about when you're thinking about who your guardian would be, a lot of people will specify my brother and his wife. Well, do you really want both your brother and his wife? And if you do, is that really okay with you long term? Think about the implications. Let's say you have your brother and your brother's wife, your sister-in-law, and something happens and they become guardians. Do you want, if they got divorced down the road, would you be okay with your future sister-in-law becoming the guardian as well? Could she sue your brother for custody? The answer is yes. If you've specified her as a guardian as well, she has equal rights. So be careful there. If you just want your brother as guardian, just list your brother. So make it very clear. So we also specify any funeral or burial instructions and how the will and the trust will work together. So one thing we also look at is how we handle real estate. Real estate is going to be dealt with a little bit differently depending on your jurisdiction, but it has to be put into the trust as well. And you have to look at what your county says, but usually it's done through a deed of gift, which basically says I'm giving a gift to the trust, and the gift that I'm giving to this trust is my house. You still own the house, but it basically sets it up so that if something happens to the owners of the house does not go to an 18-year-old child, but instead the house goes into the trust so the equity of the house can be distributed in accordance with your trust. So it makes it all kind of work together. One other thing that we do as part of this process is called your tangible personal property. Tangible personal property is your stuff. We're on the next slide. Your actual stuff. Your tangible personal property says, this is what I'm giving to people. So my jewelry, my china, my family heirlooms, things that are important to you because they are worth a lot of money or because they have a lot of sentimental value to you. And this is basically say who gets what. So if there's something that's been in your family for generations, you want to specify who it goes to. Now, generally speaking, this is not kind of an inventory of everything you own, but it's more about the things that really matter to you because they're either worth a lot of money or they have a lot of sentimental value. So you may have specific people in mind, and my engagement ring will go to my daughter, etc. And now this is also something in most jurisdictions that you can modify as you're working through it, and you don't need to have an attorney change for you. Depending on how you structure it, as opposed to the wills and the trust, that you actually do need to have an attorney modify those for you, because if you just do an amendment that you type up or you handwrite on it, then usually that's considered invalid and will not be held up by the courts. So we'll go on to the next slide. Part of creating an estate plan is also looking at an advanced medical directive, and this is basically specifying what would happen to you if you were in a persistent vegetative state. If you watch any kind of TV shows that I like Grey's Anatomy or ER, yes, I watch bad TV, then you probably have seen them talking about this. If you were in a persistent vegetative state, what would you want to have happen on life support? And there's shades of the gray here. Would you want your body kept alive until you were for forever, for not at all, until your loved ones could come say goodbye, for 7 days, for 30 days? How do you want to have that decision made? For women, if you were pregnant, would you want your body kept alive till the baby was brought to term or not? Also situations about organ donation. Do you want to be an organ donor? For any purpose, for saving the life of a loved one, for no purposes at all. We also look at questions dealing with what happens long term with everyday decisions for medical care. Let's say there's an accident that is serious but not life-threatening. Who's going to make decisions authorizing the doctor to do a blood transfusion or perform a risky surgery? For many people, that's usually their spouse, but what if the spouse is in the accident as well? For single parents, this is especially important because there's no given person to make this decision for you. But even if you're married, you should still have this, because if the spouse is also in the accident with you, who's next in line? Is it a sibling? Is it a friend? Is it a parent? Who is that person who can authorize these decisions? Next slide. The same idea here is that we also create power of attorney, similar to the Advanced Medical Directive, but it states if I was in a persistent, if I was something had happened to me and I was incapacitated, who's going to handle legal and financial decisions for me? This is the idea saying that who's going to sign authorizing my health insurance to pay my medical bills? Who's going to pay my mortgage, pay my child care, pay my credit card bills, as well as kind of for everyday things if I simply cannot be there. Say I'm away on vacation and a storm comes through and damages my house. Who's going to handle signing, authorizing my homeowner's insurance to make the repairs? So it's an important document to have, and a lot of married couples mistakenly believe that they can sign for each other just by being married, and in fact, you cannot, and I've had this happen just me and my husband. So having a power of attorney is something that's really quite helpful. We keep ours on our Dropbox or on our phones electronically, so I can pull it up whenever we actually bought our first minivan and used it to sign it since I had to leave because, of course, the 3-year-old was throwing up. So, having this kind of a thing readily available to give your spouse the ability to sign for you can actually be quite helpful. Next slide. So a couple of, we're going to wrap up and then I'll open up to questions with a couple of tips that I wanted to share with you all as we're kind of talking through the big picture questions here. So a lot of people think, well, we can't decide. One of our biggest decisions is who we'll have as the guardian, and we're just going to kind of punt on this for a long time because we just don't know. Having something in place is better than nothing. If you have nothing in place, you can't decide, so you never do anything, the worst fears could happen. The person you least want to have the children could end up with the children. One of the biggest questions I get asked is about whether or not you can use the internet to create a will. I see these things all the time. LegalZoom, Rocket Lawyer, all sorts of legal documents are created online, and the reality is that these documents do not stand up in court. There was an article in Consumer Reports about 2 years ago that kind of reviewed a lot of these online legal documents. And the reality is that many times they are not recognized by courts. Kids have ended up in foster care, and they don't really reflect what you want. And they're based on the wrong state's laws. I've had a number of business clients who've downloaded documents online or done business formation documents online, and they simply are incorrect and are in violation of a lot of local law. So be very, very careful here. Also, if you're creating a trust, there's a lot involved with funding the trust. So you have to make sure that the funding of the trust is done correctly, thoroughly, comprehensively, in an ongoing basis. So those are the things to avoid. The things you should look at is making sure you look at your documents every now and then. I usually recommend to our clients to update their documents about every 5 to 7 years, depending on what's going on in their life. Have you had another baby? Have you moved? Have you had a major change in life? If you've gotten divorced, obviously that's a big one. If you have moved and bought another property, if you've changed jobs, these are things that you want to update your documents, go back to your attorney, and make sure the documents really reflect what you want them to say, as well as being updated with the state and federal laws. These laws change regularly. And here in Virginia, we just had a major change to the law in 2012, and it changed the laws across the board. So make sure that your documents are updated regularly, and work with an attorney who's going to help you really accomplish your goals. Any attorney should be available to answer questions for you and make the process as comprehensive as possible, but also easy to navigate. So I definitely recommend working with an attorney in your area on this, and making sure that you're comfortable with the process, because they're your documents, and at the end of the day, the purpose of this is to give you peace of mind. Many of my clients say when they are done with the process that they are so grateful to have peace of mind that they know if something happens to the parents, they'll be taken care of, the kids will be taken care of physically and financially, and for many parents, that's such a burden lifted off our shoulders. So I'll wrap up and I'll turn it over for questions. So Sarah, I'll let you go ahead.
Great. Thank you so much, Rebecca. Not only do you obviously have amazing expertise in this subject area, but again, I think your perspective as a mother also, and really being able to relay this to folks in an easy to understand way is awesome. So thank you so much for being here. We have a number of questions. So I'm going to just kick it off with the first here in order. So somebody had asked, in terms of becoming a new parent, when should we put a trust in place? Should we be doing this while we're pregnant?
It's a great question. I get that a lot. So what I usually recommend is that we should start the process at beginning. So before you have the baby, once you're pregnant, we usually start working with the client to draft all the documents and then have everything done and ready to go once the baby's born. Because after the baby comes, you simply don't have as much time to review the documents. So have everything done in advance. Work with your attorney. Go through the drafts. Finalize everything. I would sign the power of attorney and the advanced medical directive, because when you go to the hospital, they're going to ask you, do you have an advanced medical directive? So you can finalize those. Everything else can be finalized, but I wouldn't sign it until after you have the baby. Then you have the baby, go back to your attorney and literally just say, this is the baby's name, and they will put the baby's name in, and then they'll give you the steps to then go about signing it and getting it finalized. And later on, it can obviously be updated when you have more children, but I usually recommend get everything done before the baby arrives, because when you are in the sleepless nights of a newborn, this is the last thing you want to deal with. So get it done before, and then you can just update it after the baby comes.
That's great. Thank you so much. Another question came in. What is the best place to start if you don't already have an attorney to do this for you? How do you find one that's reputable that also won't charge you an arm and a leg?
So, the fees on this really are going to vary. If somebody sounds too cheap, then it usually is they are too cheap, because they're going to have a lot of hidden fees. You should always have a contract with your attorney and have it in writing. Where to find an attorney? First of all, the best place is usually asking friends for referrals. If none of your friends have been through this process, if you have a financial advisor. We work with a lot of financial advisors. They refer their clients to us. So look for a financial advisor in your area. If you have an accountant who handles your taxes, that's another good person to ask for that. And oftentimes, if none of those people are in your life, ask people who are older, grandparents in your neighborhood. They usually have done this already. So those are people to ask. And then if it all else fails, you can go to local bar association, and they will have a list of referral partners.
Great, thank you. I think we have time for one more question, and that came in, again, about trusts. So who manages the actual trust for the children under 18 in the event that the parents are gone? The guardian or the executor from your slide, and how do we make sure that there's accountability so that the money is actually spent the way you wanted it to be spent?
It's a great question. It's a really important area. So you actually appoint a trustee. The trustee is the person who's responsible for distributing that money. And the trustee does not have to have any sort of background dealing with money or finances or law or anything like that. It's really someone who you trust, who will have your children's best interests at heart and will advocate for them and use the money responsibly. So when your 17-year-old comes to that trustee and says, hey, I want to go buy a Lamborghini to take with me to college, the trustee will say, yeah, nice try. Here's money to buy a used Honda Civic. So it's somebody who will make reasonable choices for your children financially. Now, people ask me regularly, can the guardian be the same person as the trustee, or does it have to be different people? I'd say my clients do about half and half either way. For example, I have the same person listed as my guardian as they are the trustee as executor, because many people have one or two people in their lives who they trust implicitly more than anyone else, and it can be that person listed for all these roles. Other people like to split it up, having a different person as guardian than trustee to make sure there's more checks and balances, or to involve both sides of the family, mom's family and dad's family. It's really up to you. The person who serves as the trustee in most states has a legal fiduciary responsibility to show the accounting, to show the reporting requirements of what money is actually being used in the trust. I actually was just involved in a court case where my client was the beneficiary and the trustee had not shown the accounts, and we sued to get the reports because some of the money was questionable. So you want to make sure that your trustee is simply someone who you trust. They will use the money responsibly. Now, if the person is the trustee and the guardian, they can use the money for basic things like raising the child. There just has to be an accounting for that. But the most important thing in choosing someone for these roles, who is going to take care of the children as best they can and have the children's best interests at heart, and that's really the most important concern here.
Great, thank you. These were really great questions, so thanks to everybody. Before we wrap up with you, Rebecca, I wanted to make sure we mentioned that I know on your slide you had offered free consultation to people, and that's in a few states, right? Did you want to mention
Sure.
Or-
My firm practices in Maryland, D.C., Virginia, and North Carolina. I actually just recently hired an attorney also in New York, so we're looking to expand there. But Maryland, D.C., Virginia, North Carolina are the ones that my firm practices in. And we do offer a free phone consultation for new clients. So if you are in one of those areas and you are interested in doing estate planning, please send me an email. I can be reached at office@thegellerlawgroup.com, and that is, I believe, on the last slide there. So I'm happy to set up times to talk with people, and we can see what works best for your family. And thank you, both Sarah and Nicole, for having me. It's been a pleasure.
Great, thank you. I'm going to turn it back to Nicole and let her give our concluding remarks.
Great. Thanks, Sarah, and thank you, Rebecca. That was amazing. You did such a great job of breaking it down for someone like me who is not an expert in this field, so I really appreciate that. Thank you so much. All right, everyone. We will probably post Rebecca's email since she just said it here. I know some of you might be watching later. We will post that as well so that you have that information. And you can leave questions and comments below. We know that sometimes the best conversations take place after the webinar, so please leave your comments and questions. We love hearing from you. And don't forget to share this link with anyone that you think could benefit from this. I know I can think of quite a few people off the top of my head that would really benefit from this information, so feel free to share this. As I mentioned earlier, our next webinar is in a few short weeks on October 6th. I think it's 2 weeks from today to be exact, and registration will open soon, and you are not going to want to miss out on this event. If you are not already on our mailing list, you can sign up on the Motherhood Uncovered website. That's motherhooduncovered.com, and that's where the details are going to be for the October 6th event. But I'm going to give you a quick VIP sneak peek since you are taking the time to watch this, and we do appreciate your time. We are going to be teaming up with another top-notch speaker like the one you've just heard and a couple amazing companies to offer you not only relevant information on the next topic, but a giveaway as well. And these are going to be products that parents are not going to want to miss out on. They're a must-have for every parent out there. So we're going to give you a few different ways to win. And so register and follow us on our social media at NizAware and at Sarah Wells Bags, and we'll keep you guys posted and up to date. And I just want to say thank you. Again, we greatly appreciate you and your time. And if you want to leave a comment below and share the video, as I said before, if you found it helpful, that's great. Thanks for joining, and we look forward to interacting with you at our next event. Thanks, everyone.
Great, thank you.